are back with episode 2. I am here with my co-host and producer, Lacey Gee.
I was going to see how you were going to say it.
Yeah,
How
I
are you,
know.
Mark?
I keep doing it the wrong way. I want to say Lacey Gee every time, which is right, but it's wrong.
It is right. It is right.
When are you going to go back to that, by the way? Are you
Never.
You're
Never.
just going to stick with the G, not with the Gee?
Yes. My grandparents went by Gee. That is how you pronounce it. But in elementary school, someone said if you put key on the end of your name, it would be geeky. So after that, I changed it to G. That's what my parents went by anyway. That's what everybody else went by. But I was that person who corrected everybody.
So in preschool, you decided to change your name.
Going into middle school, in elementary school, I corrected everybody. And then going into middle school, I quit correcting people because everybody else assumes it's G. But now there are rare few like yourself that call me Gee.
It just
like,
sounds right. So wait a minute. So your grandparents went by Gee. Mm-hmm. Your parents hypothetically would be Gee. Mm-hmm. Do they still go by Gee and not G?
They all went by G.
So starting with your parents, they went G, and they'll naturally it progressed down to you, and you're G now. Mm-hmm. All right.
But I was a rule follower. I was a hardcore rule follower. So I was like, nope, you're saying my name wrong. Until someone said, put key on the end of your name. It would be geeky. After that, I was like, I don't want to be geeky. I'd rather be G.
Well, there you go. Mm-hmm. Top G, right?
Yeah.
Well, I'm here with Top G then. And for episode 2, the last episode, just to recap, we talked about DWI and what to do if you get pulled over, which essentially is say nothing. Just tell the officer, hey, with all due respect, can I talk to my lawyer? He's going to say no. And you say, look, if I can't talk to my lawyer, I don't feel comfortable answering any other questions. You're going to go to jail. But then what is the next step?
What is the next step, Mark
What should a
Lassiter?
person do? You've been charged with DWI now. You've been to jail. You've been through the process. By the way, before we kind of go any further, I should probably prepare our audience for what happens in jail, because everybody has a little different idea. Nobody really knows. They think about it like the shows of, what is that?
Orange is the New Black.
Orange
That's
is
exactly
the
what
New
I was going to
Black.
ask.
It is
like
nothing
that?
like Orange is the New Black, because you're going to jail and not prison. So let's make the distinction.
Okay.
Jail is where you go, which is the county, which is usually you're waiting for your charge to be resolved. Prison is your charge is resolved and you're serving time.
Okay.
And you're going to be there a lot longer than a few days or a few months.
So I would imagine prison might be, I guess, kind of more relaxed because it's a long term.
You tend to have people that if they are in jail and they are going to be there for a long time, they would rather be in prison simply because everybody has a place in prison. When I was in the Army, the worst place to be was waiting for training, waiting for a spot to open up for airborne school or for ranger school or for pathfinder school or whatever school that I was going to when I was infantry. The worst spot was waiting. Once you're in the training, it's very regulated. It's very systematic. Everything is standardized. You know what to expect. Whereas in jail, everything is different. Every day is different. You think it's the same, but it's not. You would rather be in a place where people can visit you a lot easier. Now, you don't have as much access to your lawyer, and you're usually hours away from the nearest good city, but still, it's very regulated. So
I would think jail would probably be scarier because they don't want you to come back. So jail would be tougher because they're trying to not get you to stay there or to come back. But then once you're in prison, they're like, you're going to be here for a while. Don't get comfortable, but I don't have to torment you every day.
Most of the time, you would prefer to be in prison versus jail. If you're a long-time offender, you're going to be there for a long stretch. Most people that go to jail are not there very long. In fact, I would say 90% of the people that go to jail are for DWIs, possession of marijuana, possession of drugs, something along assault, something along those lines, and you can bond out. So that'll be the next step that we talk about is the bond out process. But the thing to know about jail is it's meant to be short term.
Okay.
So when you get arrested for DWI, you are going to go to a local jail. Now, it may be a municipality. That municipality sometimes have judges that are going to be there that will do what's called setting a bond. They will arraign the defendant. They will arraign you that has been charged and say, you have been charged with this offense. In this case, we're talking about DWI. So you're going to be arraigned for DWI. So you've been told by a judge, you've been charged with DWI. Then the judge has to set a bond. Now, the law says he has to set a reasonable bond. Now, I'll tell you, in the DFW area and typically around the state, it's pretty much the same. They view first-time offenders on DWIs, a standard bond would be $500. So what you do then is you've now been charged, you've been arraigned, you've been told, and you're in jail in whatever your local municipality is, that this is what it takes to get out of jail. So you can call somebody, which is why back in the day, I used to have my numbers memorized because it was before cell phones. So I would recognize you need to have a number memorized of someone that will answer the phone in the middle of the night. Wherever you are out there, people, you need to know the number.
So I probably need to memorize another number besides my ex-husband and my mother, because I don't want to call either one of those. In this instance, I would call my mom on a regular instance.
So let me ask you, if you called your ex-husband, would you say, serves her right?
Probably.
So we should probably lose that number entirely. But,
yeah.
you know, a parent is a good number for a lot of people. And if you have a significant other, memorize that number. But whoever's number it is, memorize a number. That way, if you're in jail, when you get that phone call that everybody loves to talk about, I want my phone call. By the way, you only get the phone call when the jail gives it to you, not when you are arrested, not right then. You have a right to make a phone call when they give you that right, not before. You make the call and you say, hey, I've been arrested, whatever the offense is. In this case, we're talking about DWI. I need somebody to post $500. Now, hopefully, you know my name by then. And you go, call Mark Lassiter. You call your significant other, you say, call Mark Lassiter. His number is 214-845-7007. Send him an email. Get him on the phone because he knows the process. My email address is mark at LOM as in Mark, T as in Tom, L.com. So mark at LOMTL.com, and we'll put that at the bottom of the screen so you can see it, make it easy for you. Memorize that number so that the significant other can have that number. If not, just tell her to look up Mark Lassiter on the internet. I'm the first 10 things that pop up.
He's the guy with the cool podcast. So just Google Mark Lassiter and you'll be able to find him.
And we will walk them through it. But just so everybody knows what the process is, after the judge sets that bond, and you call your significant other and say, hey, my bond is $500. If you multiple DWIs, it'll be probably $1,000 to $1,500. If we're talking about intoxication offenses that are like intoxication assault or intoxication manslaughter, your bond might be $25,000 or $50,000. It's important to know what that amount is, because if you use a bondsman, because attorneys don't typically post the bonds themselves. We employ bondsmen, or the bondsmen are independent contractors, and we refer you to them, okay? And then you will post usually 10% of what that bond is. Now, in DWI cases where it's $500 bonds, the bondsmen can't make any money, so it's typically a couple $100 to get you out. But if you have a $2,000 bond, it's probably going to cost you the same amount because it's 10%. So it's $200. If you have a $10,000 bond, they usually require $1,000 and so forth and so on. Now, the process is once they post the bond, the bondsman, then the release process happens. When that happens, all of this together can take anywhere from 2 to 24 hours. It is ridiculous. And to give you the best example that I can in this, we have a guy who's arrested for a standard client, DWI. DWI first offense, no big deal, right? He goes to his local municipality, which happens to be Southlake. So he goes to Southlake, sees the judge, and the judge is like, I don't really want to set this bond. I want to send you to the county. So when you have jail, it's the county seat. So in Dallas, it's going to be Dallas County, City of Dallas, it's right downtown. In Tarrant County, it's downtown Fort Worth. So when they say, in this case, Southlake is in Tarrant County, we're going to send you to the county, it means the judge didn't feel comfortable for whatever reason, the municipal judge, in giving you a bond. But you've already been there 8-10 hours. In this case, he'd been there 13 hours. So then they send his butt all the way down to county, which they have to transfer. So that takes another 12 hours or so. So now he's been in jail 24 hours.
And he has to wait.
Hasn't even seen a judge yet.
Yeah.
So then he sees the judge in the county. They set the bond at $500, an innocuous, benign amount. And then he posts the bond immediately because we've been involved from day one, from the moment one. We don't understand why Southlake judge won't set the bond, but it's not our purview. We can't tell him you have to do this.
I was going to ask, is there a reason, or was it just this person's unlucky day? Like, were they being a jerk or non-compliant whenever they got pulled over?
You never know. You really never
does
know.
any of that matter? Can it just be...
All of it matters.
Okay.
But we can't know because we weren't there. All we know is he didn't set the bond.
Yeah.
So when he ends up 24 hours later getting a bond set, and then we post the bond, we call over there after about 4 or 5 hours and say, hey, why has he not been released? And we are told Tarrant County has an average release time of 18 hours from county. Now, let me just describe for our audience here how ridiculous that is. You are a taxpayer. Your money goes to funding these people to do their jobs. So if you get an automated system, which they have, that says this person has a bond of X, it will automate and say when the bond was posted. So if you get a bond and it says it's X, $500 in this case, and it's been posted, it'll show posted. The only job you have to do, the only job in the sheriff's department, find that person, give them their stuff back, and let them go. You're telling me that takes 18 hours? I call a big bag of bull effing shit.
But I imagine this is like the DMV or the hospital where you hurry up and wait, where they're going to do things on their own time. It doesn't
I'm
matter.
sure that that's the case. And it's very difficult. And here I am saying this is bullshit. But as a person, if you went to that facility, you can't just tell the sheriff's department this is bullshit. They're going to keep you there longer because they have the power. Only they can release you. And if they decide not to, then there can be contempt of court proceedings, but you won't get there because they'll just release you. So at the end of the day, I will tell the audience, be nice, be courteous, try and be empathetic and say, look, we understand you have a bunch of people here, because the nicer you are to them, the nicer they are to you. But at the end of the day, I am saying as a taxpayer, I am mortified that it takes that long. And by the way, we're being told now as defense attorneys that the jails are overcrowded because of defense attorneys not getting their clients out of jail. Well, guess what? They have the ability to do what's called PR bonds and just let them out themselves. Or, hey, prosecutors, how about not giving our clients ridiculous sentences and then they won't sit there waiting to go to prison? All of this to say, the process is what we're focusing on right now. And you, as a citizen, need to be aware of the process of when you go to jail, what happens. So that's what happens. It's going to take a long time.
Well, question.
Get past it. It's the worst part of any charge is the initial arrest.
So in this particular case, it took close to, let's just say, 48 hours for this client
to get out. It was about 36 to 38 hours.
So hypothetically, if I were to get arrested for 48 hours, I would need you to call somebody. Probably my job, not my mom. Don't call my mom, but call my job. If I went to jail and called Mark Lassiter and hired you and said, hey, you've got to call my boss and tell them I'm not going to come in, is that something that you do? We
absolutely take care of that. And so every situation is different. Most people are arrested on the weekend, so you don't worry about that because it should be within a 24-hour time period, and most are. However, you have those certain situations like this where we actually had to inform people. I had to, in this case, inform a wife, an ex-wife, because there were children involved, a mother, and we stay current with all of those people, letting them know every step of the way what is happening so that they're not calling the jails and going, what's going on with ours? We call them for you and we let you know.
If I told you to call my boss, but he doesn't need to know what happened, would you also cover for me and just say?
So therein lies the little trick there. So it's not necessarily a trick, but the hitch and the giddy up is if you tell us, hey, call the boss, but don't tell him why we can't come into work. That makes it especially difficult. So what we'll usually do is see if we can find an email address and say, hey, this person is indisposed at the moment for a court setting, which is true. Please be aware he won't be able to make it in today or tomorrow or whatever the case may be.
Okay.
So we do the best that we can. You try not to lie to people because they don't like that. And it's probably not a good starting point to start off with some sort of deceit. But at the same time, if I was an employer, I would kind of want to know why this person's not here. And I'm not just going to accept, hey, they went to a court setting. So they have to be aware of that. And so I always preach to people, honesty is better.
Okay.
Especially with your boss, because if you're honest with your boss, he's going to be more lenient. I just assume under regular circumstances, they're going to find out at some point because you're going to have to attend court settings after that. So when it comes to the boss, my best answer is, hey, if you don't have to tell them and you can just do your court settings, then they don't need to know.
Okay.
But if they have to know, be honest.
Okay.
All right. So we're working through the process now, and now we know what happens when you go to jail. What should you expect? Well, what happens after that, Lacey? Because you get out of jail and you still don't know what's going on. You know you've been charged. You know you spent some money to get out of jail, typically. And you know, hopefully, the worst part is over. Then you got to take the next step, which is usually you're released under certain bond conditions, and hopefully you don't have an interlock device, which is a blow device on your car that says, hey, blow into it to start the car. And if it detects alcohol, then you're going to go back to jail. But what do? And the answer is you find a lawyer. Because if you don't find a lawyer, you're defending yourself, which is never a good idea. DWI, even though it's one of the most common crimes, is actually one of the most difficult to defend. So what I want to talk about now is if you were charged with DWI, Lacey, how do you find the right lawyer? And it's all easy and everybody can say, hey, I've done DWIs for 20 years. I know what I'm doing. But that doesn't actually answer the question because the law has changed over the last 25 years. Science has changed. DWIs can be more difficult to defend than murders because typically in a DWI case, there's a blood test. So there's scientific evidence to indicate if you did or did not actually do the offense. Can the state meet their burden? And there's scientific evidence to prove that. Whereas a murder or an assault, it's usually he said, she said. Nobody saw it.
And you said in last episode that people are supposed to be presumed innocent until they're proven guilty, but for a DWI, it's different because once they pull you over, they're assuming you're guilty and then backing that up. Whereas with the murder, you would have to prove that this took place. And in DWI, they're kind of working backwards. They're proving why you did it, not why you didn't do it.
I would say almost in every criminal case, that is the case. If you go to a lawyer's office and you say, well, hang on a second, you know, I think we can win because I'm in it. They can't prove that I did this. And I have that all the time where the client comes to me and says, well, let's take a simple thing like slurred speech. You come in and even though we utilize this, slurred speech is something that is a fact or is a non-fact, right? Either you have it or you don't. It's objectively there or it isn't. Now, even if you have slurred speech, it doesn't mean you're intoxicated, right? Pretty simple. What if that's just how you speak? What if you're foreign and it sounds slurred, even though it's not, it sounds slurred? So like I said, we're going back to an objective fact. And the client will say, well, that doesn't mean anything because they can't prove that the slurred speech was from alcohol. And I said, that's right. That is the way it is supposed to work. But when you are interviewing attorneys, ladies and gentlemen, you need to ask this question. Well, wait a minute. Is presumption of innocence, does that actually hold true? And what I mean by that is you're sitting there and the attorney says, we can defend it by doing this and this and this. What he should know, or he or she should know, is that people are typically presumed guilty, even though that's not the way it's supposed to work. And we do something called jury selection, in which we all promise that you're not going to presume somebody's guilty before you start the trial. Guess what? If you're sitting in the jury, Lacey, and somebody is sitting there and they say, this person has been charged with this offense, are you sitting there thinking there's no reason that they were charged? It was all made up and they have to prove every aspect of it?
No, I was raised and taught to believe the police. So, I
That's
mean,
right.
I'm going to assume that this person's probably guilty and they're going to have to convince me otherwise.
That's exactly right. And that is the mindset. And the difficult part is finding an attorney who can change that mindset, who can explain to a potential jury, this is what it really means. This is how we have strayed from that. Okay? And they see that only when they want to. You know, politically speaking, let's take a case like George Floyd, where they presumed that the police did something wrong, right? Before having any of the facts because of the result, right? The death was tragic, but we presumed that the officers did something wrong. Now, here's the interesting part. They probably would have gotten away with it had it not been on video. But at the same time, we are wrong in society to think that's not how the police officers are trained. That's how they treat almost everyone. That's why you have these cases all the time where the police don't really help a situation. They actually make it worse a lot of the time. Somebody ends up always going to jail, which you don't want that to happen. You want the officers to protect and serve it. And nobody's saying there's not good officers out there. There's plenty. In fact, some of them are my best friends. But at the same time, the training is not there because the money is not there, because like school teachers, we pay our police a pittance to do a job that they're putting their lives on the line for. And it does not saying that they don't make mistakes, but what you need to do is be, as a trial attorney, be empathetic with that officer, but also explain what's commonly known as confirmation bias. And we're kind of getting off track here, talking about what an attorney should know, but it follows suit with this, is an attorney should know what confirmation bias is. Confirmation bias is when, Lacey, I've determined that because you're white, right, you know nothing about black culture. And everything that I see or hear from you is going to confirm that bias that I already have in my mind, right? Much like a police officer, if he suspects prior to detaining you, like prior to pulling your car over, he sees your car weaving. Then he pulls you over, you pull over normal, and you get out of the car and you start slurring. He's going to suspect and believe that because you are slurring, it is due to intoxication. He smells the odor of an alcoholic beverage. He thinks that's due to intoxication. You don't perform well on the standardized field sobriety test. He's going to believe that's due to intoxication. And guess what? He may be right, but he might also be wrong. And the difference of innocent until proven guilty and beyond a reasonable doubt is the ability for the attorney to show that there is a possibility along this way that you presume something to be true without actually doing a thorough investigation. And the simplicity of it is, let's take the slurred speech. Officer, you believed that Lacey had slurred speech due to intoxication, correct? Did you ever ask her if that's how she speaks normally?
Have you ever listened to any of her podcasts? Because she butchers
Right.
English all the time.
Have you checked with a friend? Have you talked to her? Whatever the case may be. But with one question, you could have eliminated the possibility that this was anything other than alcohol. But you chose to allow this jury to try and figure that out on their own, right? That's what you did. And that's not because you're a bad guy. It's probably you just forgot, or maybe you weren't trained. But with one question, you could have made something clear. And let me ask you, officer, this is what you would do in cross, a good attorney. Are juries supposed to guess at what is true or not true, or are you supposed to prove it?
That's good.
And very simply, with one thing, I can establish that the officer, whereas I'm not attacking him, I'm just saying, look, you didn't go as far as you needed to go for this jury. Now, if I can do that with something as simple as slurred speech, I can do that with every aspect of the case.
But you have to ask the attorney when you're screening them to see if they're going to represent you on this case. You have to ask them, what is the question? If it's
So getting back to it, do you know about confirmation bias?
okay.
All right. So
Because I would just assume they would have your back anyway. If you're paying an attorney, it would be to kind of get me out of this. But that doesn't mean they're going to.
That's a very good point, Lacey, because, okay, getting back to how do I figure out what attorney to hire? In this business, I have found that there are 3 types of attorneys. There is the competent, I know what I'm doing, I'm going to do the best job that I can for this client, and I'm going to treat this client like family. I like to believe I am in that category. There is another category of attorneys that are competent, but they're doing it for the money. Now, granted, I wouldn't do it without money, but I have always lived under the belief that if I do a good job for you, the money will take care of itself, because I'm going to quote you a fee and you're going to tell me at that time whether or not you believe that you can afford that and that I'm worth it. And that's why you hire me, because you believe that fee is appropriate and you believe I am competent to get you the best possible result. And going back to what you said, an attorney is not hired to get you out of things. An attorney is hired to get you the best possible result. And sometimes that doesn't mean getting you out of it. Sometimes that means getting you the best possible punishment or consequence for your actions. Because there are indications, like, for instance, I had this one guy who came to me and said, hey, you're going to win my case. It's super easy. I didn't do any field sobriety tests. I didn't admit to anything. And I said, you're right. It does sound super easy, but let's see what the facts show. So we charged him an appropriate fee. He agreed that that was the appropriate fee, believed that I was competent. We got the discovery back. We looked at the evidence. And when we looked at the evidence together, there was a videotape, and the officer asked him, hey, do you want to do these field sobriety tests? He goes, nah, I'm too drunk for that. Well, at that point, we're not winning the case.
But yeah, I would think you do not say that. Instead, you say, with all due respect, I would like to call my attorney.
That's exactly what he should have said. But instead it was, nah, I'm too drunk for that. What's funny is he was sitting on the ground at that time, and the officer walked up and he goes, hey man, I need you to stand up and do some field sobriety tests. And he's like, nah, man, I'm way too drunk for that.
Wow.
But in those particular cases, interestingly enough, that was a felony DWI because it was his 3rd offense. And we could not win the case. He was facing prison time, and we managed to get the case reduced to a misdemeanor by doing some mitigation work, convincing the prosecutor that this was a man worthy of rehabilitation. That's all behind the scenes, but getting back to it, like, how do you know if that attorney is going to do the job? Because like I said, when we move from the attorney who's competent, who's going to take care of you like family, to the attorney who is concerned about money, and I see so many of these, you're just dollar signs to them. So how do you figure out if a competent attorney is you're just a number? Well, simple questions that you can ask. All right. Will you be honest with me if there's a good thing or a bad thing, right? You can gauge their responses. Another thing is look at their reviews. That is quite possibly the best way to choose. And keep in mind, attorneys that are competent can have bad reviews. And those reviews are usually not, he doesn't know the law. They're usually, he doesn't communicate with me. He did not explain to me the process. A lot of the time, attorneys call this hand-holding, the client that always wants to know what's going on with their case. I believe that it is a defense attorney's job to tell the client what is going on with their case, because it's not my anxiety. I'm not the one who has the potential of going to jail after the case is over. You, the client, are. So you, the client, need to know that your attorney cares about your mental health.
But I would also think, if you think like me, yes, I'm a G, but I'm also not just a
You're
regular.
a top G.
Yeah, I'm not just a criminal or anything. I would think you would also get a bad review if someone thinks like me and thinks an attorney is supposed to get me out of trouble, but due to the crime and the evidence, like maybe you didn't get them out of trouble, you got them the best punishment, like you said, but then that could still garner a bad review as well.
And that's a great question. And the answer is if the attorney did his job properly. So if you came to me and you said, Mark, hey, why didn't you get me out of this? Well, the answer you would already know, because I explained and went through the evidence with you. And we discussed what might happen if we went to trial and lost versus pleading the case. We discussed your chances of winning, your ability, right, to have a better outcome by going this route versus going to trial and getting a not guilty. For instance, let's take the example of the guy who sat on the ground. Nah, I'm too drunk for that, right? There's no real way to get him out of that. So part of my job, and this is, I believe it's my job. Now, not all attorneys believe that, but I believe it. I need to explain to you why that's bad. Now, it should be self-sufficient, right? Self-evident. I can't prove that you're not intoxicated if you're saying you're intoxicated. But at the same time, he needs to understand why this is a good idea for him. And if I do that correctly, and in this case, we got him down to a misdemeanor, he was ecstatic because he understood not only was that a good result, that's a result that probably hardly any other attorney could have obtained. So if I did my job, you would not leave that bad review saying I didn't get him out of it, because he would be leaving a good review saying he thoughtfully explained everything that happened, why the evidence was good, why the evidence was bad, why this was a good idea for me. Now, he has the option of going to trial. And of course, in that case, I would have given him like a 1% chance of winning in the event the officer like died and couldn't testify or something like that. But in those cases, you always explain to the client, I do, here are your options. Here's why I think this is the best option. And if I did that honestly, then you, the client, are going to feel that you're being taken care of. Not only taken care of, but taken care of like family. That's one of our mottos we have at Lassiter Criminal Defense is we take care of you like family. In other words, I am not going to recommend you do something that I wouldn't recommend for my own child or my own family member. And I've had to do that. And it hasn't been fun. But I have said, this is the right way to go because you messed up.
Do you charge your family?
Unfortunately, no. But getting back to that, how do you decide between, lawyer A, lawyer B, if they're both competent? Look at the reviews. If you look at the reviews, other people have already gone through this process with that person. They know what they went through, if it was a good experience or a bad experience, and they will put that on paper. And if they had a really bad one, they're going to put that on the internet. It's going to be out there. Whether that's a Google review, whether that's a Facebook review or something else, you're going to be able to read about other people's experiences. That gives you the best idea. The other thing that people often look at when they're deciding what attorney to hire are results. Does that attorney obtain good results? Because there are competent attorneys who don't like keeping their clients informed, are very bad at communication, but they get good results. Well, that's something to take into consideration. The last category of attorneys are the incompetent attorneys, the ones that have been doing it forever, or the brand new baby ones that say they can take care of it, but they really have no idea what they're doing. And so you as a person need to be able to flush that out. How do you determine if this attorney is competent? Like, you can look at reviews to determine whether or not this person is just about the money. You can look at results to see if they get good results or not. Because you should never believe an attorney when he comes in and says, I get the best results. Don't believe him. Because I have found, just like if you want to meet a tough guy, don't talk to the guy who says he's tough. He's probably the least tough guy in the room, right? The tough guys don't have to say it. If a lawyer has to tell you I'm the greatest, he ain't.
I've always felt that way about people that say I'm funny. If you have to tell me that you're funny, then I'm not.
Oh, man, I have to say that all the time.
No. And you don't have to tell people that you're a good lawyer, because you are.
It's true, because the results speak for themselves. So talking about how do you figure out who is a competent lawyer that you should decide to hire specifically for DWI. So let's talk about that. What I would want to know is, first, do they know the process, right? The bond out process you've already been through, but they should know it. And you know they know it by asking a simple question: were you required to have an interlock? The attorney should know that, because that is an added condition of bond that will sometimes plague you as a individual, that will also come back and bite the attorney, because if you have any alcohol, then the attorney has to fight that alcohol violation or you go to jail. So if the attorney asks that question, were you required to have an interlock? It's because he knows that anything that triggers that is going to cause him more work. So he makes sure, like I would, in saying, hey, by the way, mouthwash, that has alcohol in it. Cough syrup, alcohol in it. Toothpaste, alcohol. Perfume, alcohol. Cologne, alcohol. All of these things will set off that interlock device. So it's important, if you take any of those things, rinse your mouth out with water, wait 15 minutes, and then drive. It's unbelievable to me how many of my clients all of a sudden are addicted to mouthwash, right? I've never used mouthwash, haven't had a need for it, brush my teeth all the time. But these clients that all of a sudden get DWIs and they get interlock violations, it's like, oh, it's mouthwash. I'm like, when did you start using mouthwash?
You know how I know that you don't brush your teeth all the time? Because
How?
you just said that you brush your teeth all the time.
Oh, man, caught me in my own game. Oh, too smart, Lacey, too smart. That's why you're top G. But going back to it, okay, so that's one question that you would expect the attorney to ask. Another question that you would expect the attorney to know is, what happens to my license? So most people don't understand this. When you get charged with DWI, you actually have two separate cases that go on at exactly the same time. One is called the ALR, the Administrative License Revocation. And then the other is your criminal case. The ALR is a civil case that is separate and apart from your criminal case. So the moment you come into my office, the first thing you're going to hear me talk about is the process. If you are interviewing attorneys and they don't talk about the process first, they're the wrong lawyer.
Okay.
Because you are not now being informed about what to expect. I have always found that expectations, if you set out expectations and those expectations are met, everybody's happy. When I did a counseling therapy thing one time, right? Not to go too far into it, she said, what do you see as the biggest issue? And I, in one word, said expectations. She expects this without voicing those expectations, whereas I voice my expectations and only get upset when those are not met. And once we voiced our expectations, our relationship went, perfectly. I say perfectly. You're going to have bumps in marriage, but as well as can be expected. In a client relationship, I feel, just like family, it's kind of like a marriage. You are hiring me. We have to have a trust. And to have that trust, I need to set the expectation. So I set the expectation in the initial consult where I say, this is the process. So, ladies and gentlemen, when you meet with your attorney, make sure he sets out the process and gives you expectations. So my expectation, if you came to me, would be, here's the process, Lacey. You're going to have an ALR. That ALR needs to be defended. because that is a way to win the case. If an attorney doesn't want to do the ALR, then you need to leave the room.
And that's the license?
The Administrative License Revocation Hearing, ALR. Now, what you do is you have to request a hearing within 15 days of the date that you were arrested. That's very important. If you miss that deadline, you have no right to a hearing and your license will be suspended. Now, that's if you refuse to provide a blood specimen. If you did provide a blood specimen by consent, then Texas TPS will then test your blood first. Or if it's a breath test, they will test your blood right then and there, and you'll know and you have the 15 days. But if it's a blood test, which it normally is, they will test your blood first, which takes about a month. And then they will send a notice of suspension to the address that is listed on your driver's license. So make sure you check that address, whatever that happens to be. Sometimes it's your parents' home. Sometimes it's an apartment.
Ex-husband. Ugh.
Ex-husband's home, right? But they are going to send that letter. It'll say notice of suspension to you at that address. And then you need to send it to the attorney, hopefully me. And then we will request the ALR. And that has to be done within 20 days of them sending you the letter. So if you're like me and you check your mail once a month, you might miss the boat. But the ALR is one of the most important aspects of representing someone in a DWI, because we can get that officer on record under oath and get it transcribed as to why he arrested you and why he detained you. You would not believe the number of cases that I win that other attorneys are like, how did you do that? The guy was a 0.2 something blood test, which is more than 3 times the legal limit. One guy flipped his car into a house. He comes to my office and he goes, there's no chance of winning. I don't want to pay for a representation. I'm just here because my parents told me to get a consult. So we consulted. I explained the process to him. I explained the ALR, that we have a chance to talk to the police officer, typically before they've had a chance to talk to the prosecutor, so they're more honest. That's important because if the police officer has a chance to talk to the prosecutor first, they prep them. They say, this is what the defense lawyer is going to ask. You need to answer it this way. Now, that would be unethical, but I'm sure in some form or fashion, they're saying you need to prepare yourself and get around this aspect. Otherwise, we'll lose the hearing. Well, in an ALR, that hasn't happened. So you can ask the question and expect an honest answer. I can't tell you the number of times I've had to approach an officer and say, hang on, in the ALR under oath, you said this. Now in this hearing, you're saying something different. The only thing that has changed, there's been no other investigation in this case. The case has been dead since the moment you arrested him. Your investigation was over. And you wrote this report, and then later on you gave this testimony. So what has changed between you giving this testimony and you're testifying today? The only thing is you've had a chance to meet with the prosecutor's office, isn't it? So now we've established the prosecutor's office has changed your testimony.
Wow.
Right? But this ALR is vital. It is crucial. It is how good lawyers win cases. I give speeches on this all the time to other lawyers. You, as the individual, need to know that your lawyer is going to do an ALR. So when you're interviewing on a DWI, make sure your lawyer knows what an ALR is, explains to you the process and the timelines. If he doesn't know it off the top of his head, leave the room. He doesn't know what he's doing. If he tells you he doesn't do ALRs, leave the room. He doesn't know what he's doing. And many times, other lawyers farm them out. I'm not a fan of that because you need to farm them out to somebody who does know what they're doing. And I know what my defense is going to be before I do the ALR, so I can gear my ALR and target that officer on that defensive strategy. That is the key, is getting that officer under oath to say, this is what I did, this is why I did it. And then I ask questions like, well, you don't know this. You didn't ask this question. You don't know this because you didn't ask this question. I'm gearing that officer, I'm preparing him so that when I ask those same questions in a trial, he can't back away because I've got him under oath. And if he changes his testimony, Why did he change it, Top G?
Because the prosecutor changed their mind.
Because the prosecutor got a chance to get to them. And the moment that I introduced that, the jury has doubt and said, wait a minute. That officer only changed his testimony because that state-employed government lawyer got a hold of him and told him to do it. That's what they're going to think. What else did the government lawyer tell him to do? Can we even trust this guy from now on? I don't have to do any of that. All I have to do is say, your testimony was this back then, and the only thing that has changed is you've talked to them.
So not only is Mark Lassiter a phenomenal criminal defense attorney who will treat you like family, you're also a good person because you tell other attorneys how you're winning the cases and how this is what you're doing wrong. Why aren't you doing this? So you're also sharing information that's beneficial to others and isn't just coming back to yourself.
Now, I will say in the criminal defense world, it's a very close-knit group, and we tend to share ideas, right? So I am a fan of stealing ideas from anybody that I think will help my client. And so we go to these what are called legal education seminars, continuing legal education, to try and get ideas like that. And many times I'm asked to speak at these things because they see the results that I continue to get. I get calls from attorneys all the time saying, we can't win this case. We're going to send them to you. They need to win. So I get referred the difficult cases that other people can't win, and then we win. And they say, how did you do that? Well, the ALR, that is the key to a DWI, all right? That is the key. It is quintessential. So when you're interviewing, make sure they explain the process, make sure they give you an expectation, and make sure they know what an ALR is and that they're going to do it themselves or have somebody do it that knows what the defensive strategy is going to be. Now, the other way to flush out whether your attorney is competent is going over, there are punishment ranges, but what would you see or what do you typically see as an expectation when there is no way to win, right? So if I'm going to be convicted of a DWI, what's going to happen to me? Is it going to be probation? Is it going to be jail time? Why does that matter? Because jail time can sometimes be beneficial. If you get 3 days in jail in Dallas County, 1 day counts for 3 days. So the day that you did in jail to bond out, that's your only punishment. Now, the Texas legislature has tried to put a stop to that by instituting what's called a super fine. So here's a little trick question that you can ask attorneys. If they do not know the answer, again, get up and walk out the door. They're not the attorney for you if you're looking for competence. Mm-hmm. Is the super fine constitutional? So to give you a little better idea of what a super fine is, Texas DPS used to charge what's known as a surcharge for your license. If you got convicted of DWI, you would have $1,000 a year for 3 years or $2,000 a year for 3 years just to drive. And they called it a surcharge. Well, that was legal. They have since changed that and removed the surcharge. Now you have what's known as a super fine. So if you get convicted and it's a final conviction, a conviction according to Texas DPS, you should be charged what's known as a super fine unless you're indigent, meaning you have no money. And judge has to rule on that. Well, if you have a super fine that exceeds the punishment range of the DWI itself, so in a DWI, you're only supposed to, even if it's the worst DWI misdemeanor, you're only supposed to have a max fine of $4,000 and a max probation of 2 years. If the super fine is $6,000, that's more than the maximum fine. And it's constitutionally impermissible because the statute says you cannot punish with more than $4,000.
But somebody has to know, and if not, they're still going to get charged that $6,000.
Now, I will say that basically it's become a non-issue because courts have found that if you do probation, it's not a final conviction for the purposes of the super fine. I think that that's a weird interpretation, but okay. I'm not going to fight it because it actually benefits the clients. And most of the people are ruled indigent for the purposes of the super fine. However, if the attorney doesn't know how to fight a super fine, then he's not competent because he's not familiar with the law. And that's a strange little twerk in the law, but you want to know that when you call your attorney, he's got an answer. And if he comes up and says, hey, you're going to have to pay this super fine, you're going, wait, what? What is this? You never told me about this. Remember, setting expectations. So, getting back to it, how are we going to figure out what attorney to hire? Well, first, we got to figure out competence. So you talk about the ALR. You find out if he knows the process. You find out if he knows the punishments. Then once you're satisfied with competence, you say, does he get good results? Don't ask him, look him up. Find out what his results were. They're typically going to post them. The good attorneys will post them on their website so that people can stay up to date and see under this fact pattern, we were able to get this result. But you can also look at the results by looking at testimonials that don't come from, if you're looking at one word testimonials, great lawyer, move on, that doesn't help you. But if you look at guys that say, keep me informed, communicates well, won my case in spite of horrible facts, these are the lawyers that you're looking for. So when I talk to clients and I'm getting the and I'm setting the expectations, and they ask a question that I hear all the time, why should I hire you? Or why should I hire you? Excuse me. The answer I always give is the same. You should look it up for yourself and find out if I'm the right fit for you, because you are entrusting your life into my hands. I shouldn't have to convince you of that. You should believe that without me saying it. If I have to convince you, then we're not the right fit. Because if I have to convince you, then I am trying to sell you. If you're selling somebody on yourself, then you're not the right attorney, or I don't believe that you're a good fit, because you should believe it without having to be sold, because then you're going to question it later on down the line. But if you do the research yourself and you say, I've looked at the reviews, they're outstanding. I've looked at the results, they're unbelievable. You're the guy for me, right? That's how you should go about finding an attorney. Look at results and reviews first. Determine competence when you're in the actual room with the attorney. Some attorneys do free consultations, some do paid. I do free because I believe a lot of the time you need to get a feel for who I am. And sometimes you walk in, you just have that gut feeling. And this is interesting. I saw this in a medical journal the other day. Did you know that we actually have two brains?
I did not. I questioned my one that I thought I had, but now I'm questioning both of them. We have two brains.
So you have your brain that you use, cognitive thinking, all of that. And you ever heard the phrase, go with your gut, right? Stop thinking with your heart instead of your head. Your heart actually has thinking capability. So your heart is essentially a second brain. It can tell you, you ever got that gut feeling like this is wrong, something's wrong here, I got to get out of here. That is your heart telling you, not your brain, get out. That same feeling, you will go and meet with an attorney and he will either put you at ease, make you feel comfortable, make you feel like you're going to be taken care of, or he won't. I mean, I can't tell you how many doctors I've visited in my time, and they've given me 2 seconds of their time. I spend all of it with the nurses telling them what's wrong. Doctor comes in and goes, beep, beep, okay, we'll see you in 3 months. That was $5,000, right? I never feel taken care of. I never feel like I can ask him a question. If you don't feel like you can ask your attorney a question, you have the wrong attorney. And if you start to doubt that, you can always switch.
Well, I have bad news.
Uh-oh.
I don't know if my heart's wrong or if my picker's wrong, but I know that I've definitely made some bad choices from an ex-husband to my only 2 roommates that I had were people that I liked, I trusted, I wanted to help out. 2 separate occasions, moved in, never paid me, and I had to boot both of them out. So,
well, I hate to break it to you, but you just said the magic words, right? I felt like I could help out, right?
well, but then you're helping me out too. I didn't mean you can come live with me for free. I mean, it would be beneficial.
I get it, but you wanted to help them out. If you have to help them out, there's a reason they need help.
So I don't trust myself anymore. I am dead broke in my house. And somebody was like, you really need a roommate. I said, no, that doesn't work for me. So I think if I'm going to interview a roommate, I'm going to send him to you, Mark Lassiter. I trust you a lot more than I
See
trust
if I
myself.
can interview. See,
Yeah.
when I'm interviewing somebody, it's a little different than when I am talking to somebody about who I am and what I'm about. But at the same time, I get it. I must have had 5 or 6 contractors, and sometimes we get crossways. But the reason I have found that I get cross with professionals is because of expectations. I expect perfection. I don't expect mistakes. And if you make a mistake, I expect you to own up to it and then fix it. And I'll give you an example. I'm not perfect either. So there was an instance where something got missed, right? It was a simple thing, but it did get missed. It did end up costing the client time to fix. I owned up to that and gave him $1,000 credit, even though the fix was probably $100. I said, I want you to know I'm on it. It will never happen again. We have changed our policy since then to ensure this won't happen again. But just for any inconvenience that you have, I'm going to take $1,000 off your bill. And we ended up getting a good result. And now that person refers everyone to me because, not because I didn't make a mistake, but because when one was made, I owned up to it and I said, we're going to fix it. And we're going to fix it now. And we're going to fix it to your satisfaction. Funny enough, the first job that I had out of college was a Walgreens manager, of all things. It was horrible. Not because Walgreens was horrible, but just imagine a job where I was working, I think it was 50, 60 hours a week. Nothing but sick people come into Walgreens. Mm-hmm. So I was always sick. I met a lot of great people that I worked with, but I was always sick. And everybody that came to work at Walgreens was late. And if there is one thing I cannot stand, it is being late. My dad was always late. I hated it. I remember when we went to church, my dad didn't like the singing part. And so he would arrive 20 minutes after the service had started. But the problem is my dad is deaf, like literally deaf. And so he wanted to sit on the front row. Mm-hmm. And we would walk down and there would be people everywhere. And we had 8 children growing up. So there's 6 girls and me and my brother and my mom. So there's 10 of us. It's not like one row even fits us. Mm. But he would walk all the way down. Keep in mind, my dad is 5'6" and 350 pounds. He is a human bowling ball. But he would literally walk down the middle aisle. The pastor had already started talking, given his sermon. And he would go to the front and he would look at the people in the front and go, scooch. It's not like they could move for 10 people. Still, people just started seeing that and leaving the front row open. And I would just be covered in shame. And unfortunately, now it has gotten to the point where if I experience, there's nothing you can embarrass me with, right? I'm not going to be embarrassed at all, which actually lends itself to really help me out in trial. But because I'll just say things that seem to make sense, and they make sense to me, but most people are like, how could you say something like that? I said, because that's what it is. I'm going to call a spade a spade. I'm sorry if that makes you uncomfortable or embarrassed. Mm-hmm. But like, for instance, officer, you just didn't do your job, man. Like, I'm sorry. I like you as a person, but you didn't do it in this case. I mean, can we at least agree on that? There's so many things that you're missing. The jury can't possibly make this decision. And I'm saying it just like this. And I'm not mean. I'm just saying it. Mm-hmm. Whereas another attorney would be very prim and proper and be like, you're not a very good investigator. You didn't do your, no, that's not what a jury wants to hear. They're people. Just talk to them. So when I'm talking to people, that's the same person that's talking to the jury. When you're interviewing a lawyer, and they can't carry a conversation with you, that's a problem. Mm-hmm. Because their job is to convince a jury. In the event that you can't come to an agreement, you got to know that that lawyer is capable, we didn't talk about this, but capable of going to trial and winning. If that lawyer can't do a trial or says, I'm not good in trial, leave. He's not the right criminal defense. He might be really good at the paperwork, but that guy is not your lawyer because the prosecutors are not scared of him in trial, so they won't give him the best deal. So all of this to say, when you're interviewing, recap, reviews, results, competence for DWIs, ALR, process, expectations, and can they convince a jury?
I have learned so many life hacks in this episode, including show up 20 minutes late to church just to skip the singing portion.
Oh, and the last thing that I forgot. If you did those tasks correctly, ladies and gentlemen, you have no other tasks. That lawyer will do it all for you. If he's asking you to do stuff, not the right guy. You should be taking care of everything. His job, you're paying him to have that anxiety for you. So let him do it. That's the whole, or her do it. That's the whole point. Otherwise, why hire him? You might as well do it.
Mark Lassiter, where can people find you?
You can find me at www.lomtl.com. We will put it at the bottom, or my number is 214. I'm giving you my cell phone.
I'll take that out.
We'll take that out. No, it's 214-845-7007. And you can email me at mark, M-A-R-K, at lomtl.com. Thank you, ladies and gentlemen. We'll see you for the next episode.
ProPod Digital.